jury does have a right to consider that as a basis of an acquittal. They can consider that for purposes of finding reasonable doubt based upon the Lousy investigation. In this case, it wasn't just a lousy investigation. It wasn't even an atrocious investigation. It was no investigation. In this case, Judge, the police, I think we all would agree, even the government, they basically accepted the fact that she strangled the kids are in the basement, she's guilty, and we move on. They didn't investigate anything. They didn't test the screen. They didn't even take a picture of the screen. They didn't see if there's any blood on the screen. There's no crushers for the alleged crushing of the medications. There's no indication that there's powder that she was crushing the medication to ingest the medication. There's all sorts of questions regarding the blood spatter, the blood. The police never investigated. They come into the court, they talk about their investigation through the crime scene laboratory and state police, and every question that I would ask about the door, about the blood drop on the door, about the siding, they come 6 months later or whatever, they take the siding, it's degraded, they can't even test it. I could go on and on and on with the horrific investigation in this case. So I think it would be fair for the court to instruct them on Bowden. That's it.
All right. Commonwealth, about the Bowden instruction.
So, Your Honor, we would object to the Bowden instruction. Again, counsel is free to argue whatever he wants about the police investigation in this case, but as far as failures of the investigation that have been identified in the course of the trial, I don't see that there is any. And everything that Attorney Reddington just said about what they didn't test, they didn't test the screen. The evidence shows that there has been an inadequate police investigation.
I'm going to give a manslaughter instruction in line with basically what's on page 8. I am not going to give a Bowden instruction. The defendant is free to argue that any deficiencies that he feels that are in the investigation, certainly free to argue.